Good morning, and welcome to Seacrest Wardle's special no-fault webinar to discuss the Supreme Court's recent opinion in the Andary case and how it impacts cases before and after no-fault reforms. My name is Javon Williams. I'm a member of Seacrest Wardle's Motor Vehicle Litigation Practice Group. I'm here with my partner, Justin Grimske, also a member of the practice group. So Justin, our Supreme Court has been pretty busy over the last few days, right?
Well, I'd certainly say so. In a matter of 2 days, two heavily awaited opinions regarding personal injury litigation have rolled out. Certainly the slip and fall related Candil El Saifi case, and now the Andary opinion.
Indeed. So let's unpack this past Monday's Andary opinion and whether the 2019 no-fault amendments are retroactive.
So, by way of background, our no-fault law has been on the books for over 50 years. The Act allows claimants to seek certain benefits for injuries sustained from motor vehicle accidents. Now, under the no-fault framework, an injured party is entitled to recover accident-related medical expenses and attendant care services, which the No-Fault Act refers to as allowable expenses.
It's no secret that our No-Fault Act has been frequently amended over the years also. Unless you've been under a rock, you've likely heard that Michigan's car insurance premiums are invariably amongst the highest in the nation. Many attributed this trend to Michigan's unlimited lifetime medical benefits, or PIP benefits. In fact, in many counties across the state, no-fault suits, particularly cases filed by medical providers, were seen as the reason that court dockets were backed up.
Prior to 2019, there were no statutory caps on, for example, the number of reimbursable hours of prescribed attendant care that could be provided to a covered individual by family members, as opposed to, say, a commercial provider. Nor were there limits on reimbursement rates for medical providers beyond a requirement that the cost for the service be reasonable and necessary. So, what was the response to this trend? Well, our legislature took action with the enactment of the 2019 Public Acts 21 and 22, or what has been commonly referred to as the recent no-fault reform.
Although the 2019 no-fault reform addressed several areas under the No-Fault Act, the two sections at issue in Andary were MCL 500-3157 subsection 7 and 3157 subsection 10. Now, subsection 7 imposed fee schedules limiting insurance carriers' duty to reimburse medical providers, while subsection 10 deals with limitations in family-provided attendant care rates.
Well, let's touch on the backdrop of the case itself. In the Andary case, plaintiffs Ellen Andary and Philip Kruger allegedly sustained traumatic brain injuries in motor vehicle accidents that took place in 2014 and 1990 respectively, or in other words, before the 2019 amendments were enacted. Now, following the enactment of those 2019 amendments, Ms. Andary and Mr. Kruger filed suit. They filed suit challenging the application of the 2019 amendments to their respective claims for no-fault benefits. In doing so, they made two main arguments. First, the amendments were not intended to be applied retroactively to injured persons whose accidents occurred before June 11, 2019, or by saying my motor vehicle accident was in 1990, I've been getting 24/7 attendant care since then. There's no way that this enactment applies to me. Now, the second main argument was also, even if the amendments were to be applied retroactively, doing so would violate the Contracts Clause of the Michigan Constitution.
That's right, and the defendants responded to the complaint with the motion for summary disposition, arguing that the plaintiffs, both Andary and Kruger, were indeed subject to the newly enacted limitations of 3157, regardless of when they were injured. The defendants also argued that the alleged Contracts Clause violations were baseless because PIP benefits are governed by statute rather than contract, and that the plaintiffs lacked standing to assert constitutional rights of others. The trial court granted the dispositive motion, and the plaintiffs then sought relief from the Court of Appeals.
However, on review, the Court of Appeals, in a 2-1 published decision, ruled that the 2019 amendments could not be applied retroactively to individuals who purchased policies and whose right to no-fault benefits vested before the amendments were enacted. The Court of Appeals reasoned that lawmakers did not clearly demonstrate that reform caps and fee schedules would be applied retroactively. In fact, it was held that there was no appearance of the legislature's intent that the amendments apply retroactively. Further, even if that was the legislature's intent, imposing the new limits would substantially impair no-fault insurance contracts entered into before the amendment's effective date, and therefore would thus violate the Contracts Clause of the Michigan Constitution. The court also highlighted the presumption against retroactivity.
Well, so did the court's opinion provide any clarity on the application of the amendments? The short answer, not really. Questions remained. For example, did it apply to fee schedules only at issue in this case? Did it apply to the entire fee schedule framework under 3157? Did it apply to the entire 2019 amendments? Also, the opinion did not really address whether it applied to injured persons who didn't have their own contract of insurance, specifically those receiving benefits via priority statutes, including motorcyclists and pedestrians.
So, given the complexity and the public import, the Michigan Supreme Court granted leave to address whether the Court of Appeals erred when it first held that claimants injured before the effective date of the amendments are not subject to the limitations on benefits set forth in MCL 531.57(7) and 10. And then second, when the Court of Appeals held that application of the amendment statute to such claimants would violate the Contracts Clause of the Michigan Constitution. And then finally third, when the Court of Appeals remanded the case to the Circuit Court for discovery to determine whether the no-fault amendments, even when applied, only prospectively pass constitutional muster.
So in the opinion released on July 31st, the court compared the No-Fault Act to the Workers' Compensation Disabilities Act before concluding, unlike claims under the WCDA, PIP actions are governed by both statutes and contract. Thus, PIP benefits under a no-fault insurance policy remain binding after an injury as to individuals covered by the policy unless the legislature takes clear action. The court also affirmed that the Court of Appeals holding with respect to the amendments of MCL 3157 should not apply to services and care that were already being provided to injured persons and which would have been reimbursable prior to the amendments. So one way to think of this was if you're already receiving care or services stemming from a pre-amendment auto accident, you're likely going to be grandfathered in under the pre-amendment provisions.
Now, the court held that insurance policies bind carriers to obligations that were in place at the time of the injury. Also, the scope of PIP benefits under an insurance policy vest at the time of the injury. As applied to the plaintiffs in Andary, they were both injured while covered by policies issued well before the 2019 amendments. Now, the court's reasoning was in line with the Court of Appeals decision in saying that the 2019 amendments did not clearly convey any intent to retroactively modify vested contractual rights. Additionally, there was no statement from the legislature or an intent to diminish any type of vested contractual rights.
Yeah, and the majority opinion also states that retroactive application of these specific amendments would reduce vested rights to uncapped benefits that existed under the policies and statutes at the time of the respective injuries. However, the court's holding is limited to those individuals who are entitled to PIP benefits because they were directly covered by a no-fault insurance policy at the time of their accident, either as a named insured or as a covered individual under the policy. The court was careful to state that they do not decide at this point in time whether individuals who have purely statutory claims to no-fault benefits, such as under MCL 500-3114 subsection 4 or 3115, would be entitled to these same protections.
Also, absent legislative intent regarding retroactivity, the majority declined to address Michigan's Constitution contract clause, vacating that portion of the Court of Appeals opinion. Now, further, with respect to future application of the new fee schedule, the court also dismissed that argument, holding that Andary and Kruger, with concrete and direct interest to proceed with their constitutional challenges to the prospective application of the amended statutes. The court did, however, indicate that the no-fault reform was reasonably and rationally related to a legitimate legislative purpose, specifically to drive down premiums for all operators of automobiles in Michigan, and also to curb what has been portrayed as exploitative billing by medical providers.
So that brings us back to the title of today's webinar. Are the 2019 no-fault amendments retroactive under Andary? Well, with the court's opinion, we now know that neither MCL 531.57, subsection 7, nor 10 apply to claimants injured while covered by insurance policies issued before the June 2019 amendments. The court also clarified that it sees no constitutional problem with applying the fee schedule to post-amendment accidents. In fact, the opinion reads that the prospective application of the new no-fault fee schedules in 3157 subsection 7 is reasonably and rationally related to a legitimate legislative purpose, regardless of the effectiveness or wisdom of the policy.
Now, consequently, in the post-Andary world, the critical date looks to be the date the insurance policy was issued. Also, we will likely see future litigation as it pertains to claimants seeking PIP benefits on purely statutory basis, given the majority's statement within footnote 30, which reads, "Our decision is limited to individuals like Andary and Kruger, who are entitled to PIP benefits because they are directly covered by a no-fault insurance policy at the time of their accident, either as a named insured or a covered individual under the policy. We do not decide whether individuals who have a purely statutory claim to no-fault benefits, such as under MCL 531.14.4 or MCL 531.15, are entitled to the same protections."
Well, that brings us to the end of today's session. As always, reach out to your counsel if you have any questions regarding how the law impacts any case that you're handling.
Thank you all for listening. We hope to hear from you soon.